Hello and welcome to this Building Blocks episode of Unpacking the Case, where I am joined by our Head of Legal Training here at DJB, Richard Snape, who will be talking me through the details of Crown on the application of Lewis and Redcar and Cleveland Borough Council, which relates to town and village greens. Richard, would you mind starting off by giving me a bit of background on the case?
Yeah, it's a Supreme Court case from 2010, and it was incredibly significant at the time. It was actually in the press. I remember it being in the Telegraph a day or so after it was decided. And it became a very, very good way of stopping development, so much so that legislation was passed, which sort of partially reined it back. And it's an incredibly significant case. Basically, to cut a long story short and a bit of a simplification, you can't change the surface of a town or village green, which means you can't build on a town or village green because you'll be changing the surface. Village greens do not have to be in the middle of villages and don't have to be green. They're in towns and cities as well, large, pieces of village green and small pieces of village green alike. And I'll just tell you the background legislation. It's changed over the years, but it's currently much has been amended subsequently to this case. But it's Section 15 of the Commons Act of 2006. And again, the relevant provisions basically say that to be a village green, you can make an application with the council, the unitary council, or the county, where a significant number of the inhabitants of a locality or neighbourhood within the locality have indulged as of right in lawful sports and pastimes and the land for at least 20 years. They can then stop doing so before they make an application. At the time of the case, it was for 2 years. They might not have used the land. In Wales, it still is, but in England, it's 1 year, and they can still make an application. So you might not have used the land for your pastimes or sporting activities, but they can still make this application, which takes a long time to process, costs the local authority a lot of money to process, even if it's not their land, and can scupper, at least delay the development. And that's the background to Redcar.
If you wouldn't mind, could you talk me through the facts of the case?
Yeah, it's a judicial review, as you can tell from the name, naming of the case. It was, Redcar is up in the northeast of England. It's on the southern bank of the River Tees and the estuary. This particular piece of land was some links, it was golf links on the coast, 18 acres of land, which was attached to a golf course, the Cleveland Golf Course and the Cleveland Golf Club, who leased out this land. And the lease was terminated in 2002. They wanted to build and regenerate the council on this particular piece of land, and they had plans to build 300 houses and sort of leisure facilities and recreational facilities in conjunction with persimmon on this 18 acres of land. And some of the neighbours objected to losing their links. Coton links, it was called. Hope I pronounced that correctly. And they claimed it was a village green. And the major issue was whether you've indulged as of right. It's like prescriptive rights generally. You have to indulge without force, secrecy, or permission. If you're forcing your way onto the land, if you're fencing, you're breaking down fences, you can't claim a village green. If you're secretly using the land with no one knowing for 20 years, you can't claim a village green. Or if you've got permission to be on the land, you can't claim prescriptive rights, you can't claim a village green. And the major problem is that it used to be assumed there was something called implied permission, and that it's understood that you defer to the owners of the land. They were basing the claim on various pastimes, primarily, and so it's not just playing cricket and football and this kind of stuff, it was dog walking. I've seen so many village green claims over the years, and practically all of them include dog walking for at some stage. But the other pastimes were blackberry picking was amongst them, and of course non-linear walking.
Can you just explain what you mean by non-linear walking?
Oh, we've all had nights like that, I'm sure.
Oh, okay.
Not going from A to B, ambling around without a care in the world, not just going down a defined path.
I see.
Non-linear walking.
Okay.
But the major issue was that how you got this implied permission. It's understood that you don't walk your dog on the 18th hole when there's a golf match going on. And the High Court and the Court of Appeal, when they heard this case, said that there's an implied permission. Back in 2010, in May of 2010, the Supreme Court shocked a lot of people by saying that there's no such thing as implied permission. Lord Walker said this. It must have been obvious that the locals were using this land for their recreational activities, and they sort of deferred to the golfers, not because they had to, but because that's the civil thing to do, you know. And so there wasn't such thing as implied permission, and they won the claim. It's got to be a significant number of the locals. It was actually 5 people. Kevin Lewis is in the name of the case. There was I remember a squadron leader, Kime. He sounds like a troublemaker, but who was also involved, and 3 other people. Now that's not a significant number of the locals, but apparently they put a petition up in the local fish and chip shop, you know, save our golf course, and large numbers of people signed up. And they stopped the development, basically. And it got into the newspapers, and that's how people would stop, or at least postpone developments, by claiming village greens you can't build.
In theory, then, you can't have implied permission, so it has to be express permission.
Mm.
And as long as you're not doing it in secrecy
Or forcefully,
you can apply for any area to be a village green, in theory.
There's been recent cases that say that if you hold land under statute, it can't be a village green.
Right, okay. So you mentioned dog walking and blackberry picking, but what actual pastimes do you think would be included in this?
Well, I've come across loads of cases. I mean, there was a case that a couple of years ago now involving Oxfordshire County Council, Farringdon and Oxfordshire, Alloway, Crown on the application of Alloway, and where they accepted a village green claim based on, again, non-linear walking and dog walking, also kite flying on this field. Most strangely of all was they were playing football and this kind of stuff as well, but they would chilling out and lounging about on a field, and also egg rolling. Every 2 years they'd have an egg rolling contest. The hill was called Humpty Hill.
Egg rolling and lounging about.
Sounds like my student days. But yeah, another case, example I've come across, not in a reported case, was things like sledging. There's got to be a degree of continuity, but you know, you only sledge when it's snowed. Sledging, not in the cricketing sense of the word, in the going down a hill on a sledge sense, not the sense of the ancient English custom of standing behind people, giving them verbal abuse. They succeeded based on sledging. It's the degree of continuity. When it snows, the kids would sledge down this land.
And so in this case, what subsequently happened?
Well, the whole area, the whole of this golf course is, last I heard, last I chatted around him, with the various lockdowns, I haven't been going up to the northeast or many places this last year and a half. But the whole thing no longer is a golf course. You know, so the lease was terminated for the golf course, and it was just, you know, sort of fenced off and the likes. It's in nobody's best interest. And
what subsequent developments have there been?
Well, in England, back in 2013, it came into force on April the 25th of that year, when the Growth and Infrastructure Act received the royal assent in Section 16. So it came into force on the same day to preempt people putting loads of claims in for village green in the interim. But suffice to say, if a trigger event occurs, which is basically a planning application is pending, or planning permission is being granted in relation to the land, or it shows up as development land in a development plan or a draft plan, there can't be a village green claim unless the terminating event occurs. Like if it's a draft plan, it has to go to full fruition within 2 years, or you lose your planning permission or whatever, something like that. And various other things happened in the Growth and Infrastructure Act. In Wales, provisions came in the Planning Wales Act of October the 1st, came into force on October the 1st, 2018. It's a 2015 piece of legislation where you can't claim a village green if planning permission's been granted in relation to that land, but you can beforehand. So some things have happened. And the other thing, I suppose, is in late 2019, there was a case involving Lancashire County Council and the Secretary of State for the Environment, and also a case involving Surrey. The Lancashire County Council case was a school in Lancaster with a piece of land next to the school, owned by the authority, and the locals wanted to claim this as village green, and the Supreme Court decided, I'd say just before Christmas of 2019, that if land is held through statute, then it can't become a village green, which limits dramatically in relation to government land, both central and local. But the significance of the Redcar case is that lots of people were using it, as a way of at least delaying development and sometimes stopping the developments. Hence, it became so important that they had to pass Section 16 of the Growth and Infrastructure Act, as a consequence of it, to bring back the number of cases.
Richard, thank you so much for talking me through that. I think that's the perfect place to round today's episode off. And to all of our listeners, we hope you've enjoyed this episode of Building Blocks of Unpacking the Case.